Application of Indeterminate Sentence Law. How to get maximum and minimum penalty in special law. 1. The maximum penalty should not exceed the maximum provided for by that law. 2. The minimum penalty should not fall below the minimum provided by the law. How to get maximum and minimum penalty in Revised Penal Code. Example: in the crime of homicide, under the Revised Penal Code, the offender is sentenced to reclusion temporal. The maximum penalty under the Indeterminate Sentence Law is reclusion temporal. But reclusion temporal is a divisible penalty consisting of maximum, medium and minimum periods. Which period will we place the maximum term of the indeterminate sentence? Guide for determining the maximum penalty. 1. Determine the entire range of the penalty. 2. Determine if there is mitigating or aggravating circumstance. Which period will the maximum penalty be placed? In pursuant to Art. 64, when there is no mitigating and no aggravating circumstance, it should be placed at the medium period. Thus, the maximum penalty for the example above is reclusion temporal in the medium period. What is the minimum penalty now? In getting the minimum penalty, the rule is to simply get the penalty 1 degree lower from the maximum penalty without taking into account the mitigating and aggravating circumstance. Thus, the penalty 1 degree lower from reclusion temporal, without taking into account any mitigating or aggravating circumstance, is prison mayor. Prison mayor is now the minimum penalty for our example. Important: if your maximum penalty is wrong, it follows that the minimum penalty will also be wrong. Again, prison mayor is a divisible penalty. Which period can it be placed? Under the Indeterminate Sentence Law, it would depend upon the discretion of the court on which period to place it. Thus, the minimum penalty is prison mayor in any of its period. Factors that could affect the imposition of minimum penalty: 1. Age. 2. Conduct during trial. 3. Mental or physical condition. Suppose in the example above, one aggravating circumstance was proven. What is now the maximum penalty? It would still be reclusion temporal, but it shall be placed in the maximum period because of the presence of one aggravating circumstance. How about the minimum penalty? It would still be 1 degree lower from reclusion temporal, which is prison mayor. In which period? It shall be discretionary upon the court. Other examples: 1 mitigating but no aggravating maximum penalty, reclusion temporal in the minimum period minimum penalty, prison mayor in any period. 2 mitigating, no aggravating, privileged mitigating, maximum penalty, prison mayor in the medium period minimum penalty, prison correctional any period. The preceding example is an exception to the rule. If there is a privileged mitigating circumstance, we take it into account first in order to obtain the proper maximum penalty. Then, from that maximum penalty, we obtain the proper minimum penalty by getting the penalty 1 degree lower. Same rule applies as to the period of the minimum penalty. Remember, it will never become a privileged mitigating circumstance if there is an aggravating circumstance present. 8 mitigating and 1 aggravating will never become privileged mitigating circumstance. 3 mitigating, no aggravating maximum penalty, prison mayor in the minimum period minimum penalty, prison correctional any period. In the preceding example, there are 3 mitigating circumstance present and no aggravating circumstance. The first 2 mitigating circumstance shall be a privileged mitigating circumstance. Thus, the penalty will be reduced by 1 degree from reclusion temporal to prison mayor. The third mitigating circumstance shall place the penalty in the minimum period. 4 mitigating, no aggravating maximum penalty, prison correctional in the medium period 2 privileged circumstance. Thus we lower by 2 degrees minimum penalty, arresto mayor any period. 5 mitigating, no aggravating maximum penalty, prison correctional in the minimum period minimum penalty, arresto mayor any period at most we can only lower by 2 degrees. Thus, if there are 6 mitigating circumstance and no aggravating, maximum penalty, prison correctional in the minimum period minimum penalty, arresto mayor any period. How is indeterminate sentence law applied in complex crimes? Article 48. A complex crime is punished by the most serious offense and shall be imposed in its maximum period. Example: estafa through falsification of public documents. Under the revised Penal Code, falsification of public documents, Article 171, is a more serious offense punished by prison mayor than estafa, Article 315, punished only by prison correctional. Thus, applying the Indeterminate Sentence Law, the maximum penalty for estafa through falsification of public documents shall be prison mayor in the maximum period. Minimum penalty shall be prison correctional, any period. Suppose there was 1 mitigating circumstance proven. Maximum penalty would still be prison mayor in the maximum period. In pursuant to Article 48, even if there is a mitigating circumstance present, it should still be imposed at the maximum period. How about if there are 2 mitigating circumstance and no aggravating? The rule is, if it is a privileged mitigating circumstance, we lower by the penalty by 1 degree but still place it at the maximum period. Thus, the maximum penalty shall be prison correctional in the maximum period. 4 mitigating, no aggravating maximum penalty, arresto mayor in its maximum period. In case the penalty comes from the result of a plea bargaining, the minimum penalty will be the one lower than that of the downgraded offense. Minimum and maximum penalties are specified in order to prevent unnecessary deprivation of liberty and enhance his economic usefulness. The maximum penalty is necessary for the imposition of accessory penalties, while the minimum penalty is important to allow the prisoner the chance for parole. In short, he is given a chance to redeem himself. Once the minimum term is served, the prisoner becomes eligible for parole if he proves that he has complied with the conditions imposed on him when he was made to serve sentence. Parole doesn't mean a person has fully served sentence, however. It means that he is allowed to serve the remainder of his sentence out of jail but under the supervision of an appointed parole officer. He is required to report to this parole officer on appointed dates for the remainder of the prison term. During parole, the prisoner released on parole must apply himself to a legitimate occupation and prove himself to be a law-abiding citizen. His residence will be fixed and changed from time to time under the discretion of the Board of Indeterminate Sentence Board of Pardons and Parole. The board can issue a final certification of release if the paroled prisoner has proven himself to be a law-abiding citizen. If he violates the terms and conditions of his parole, he can be arrested again. If that happens, he will have to serve the remaining term of his prison sentence behind bars.
Thanks for watching. Follow me on my other social media accounts at ms_notabene. Be sure to subscribe and click on the bell icon to be notified whenever I post. Have you more questions regarding my law school experience or have any recommendations for my next videos? Leave a comment below. See you on the next one.